Many of you who are in need of a get feel alone. You feel that there are no solutions. I'm here to tell you that you're not alone and that there are solutions. There are myths and there are facts. Myth number 1, you need a civil divorce before asking for a get. Well, that's not true. The fact is you can request a get at any time if you're no longer living together as husband and wife and there's no hope for reconciliation. Myth number 2, if your spouse will not cooperate, you should not open a file in Beit Din because there's nothing they can do. That's not true. The Beit Din has the power to do several things, even if your spouse refuses to cooperate. They can send out a hazmana, which is a summons. If he does not appear, then the Beit Din can have a hearing and rule, even in his or her absence, about whether the spouse is obligated to give a get. If your spouse is not cooperating, they can issue a siruv, a contempt of court. That siruv can be publicized together with social sanctions called the Harchakot of Rabbeinu Tam, which basically notifies all the Jewish communities that this person should not be acknowledged in any synagogue, should not be served kosher food, should not be given any of the amenities the community provides. Myth number 3, a spouse may propose any preconditions for giving or receiving the get. The fact is that Jewish law prohibits the imposition of unreasonable preconditions for the get. Unreasonable includes demands for custody, visitation, or for property or money. You cannot simply demand $500,000 for the get or demand custody for the get. Reasonable includes anything that's easy to fulfill, like returning property, personal property, or debts that were previously owed to the spouse. Those are the things that can be conditioned. Myth 4, a Beit Din may obligate a get only after all financial and custodial arrangements have been resolved. That's not true. A Beit Din may obligate a get whenever the Beit Din determines that the spouses cannot tolerate living together intimately as husband and wife. Financial and custodial arrangements are not essential. They're extraneous to the determination of whether the spouses can live together. Once a Beit Din determines that a get is obligated, it's prohibited to delay the delivery of the get for any reason. Myth number 5, there is no halachic Jewish legal procedure to void a marriage, thereby permitting one to remarry without a get. The fact is, a Beit Din may void a marriage, it's called Kiddushei Ta'ot, where there is evidence that 1, the officiating rabbi was not Orthodox or Torah observant, and or the witnesses were not kosher. Kosher witnesses are 2 male adult witnesses that are Torah observant and are not related to the bride or the groom. If the Beit Din finds that the spouse had a major defect called a mum gadol that was not disclosed at the time of the wedding. A major defect includes a pre-existing personality or medical disorder, refusal to have children, and criminal or mental dysfunction. So there are solutions. You need to find a Beit Din that are willing to use them, or you need to demand of your Beit Din that you want them to use these solutions. If you have questions about your particular case, please don't hesitate to contact me. Thank you.